Oh, something else that you had mentioned that you are super interested in is the medical examiner and the experts involved in this case. Because I know that in the UK case, the judge did not allow any experts, which to me just like boggles my mind. In a case where we are talking about physical injuries, psychological stresses on people, like these are things that require an expert. Like it's just kind of like a very basic idea in the American legal system is like you need an expert to talk about these things. You can't get that through any lay witness.
Mm-hmm.
So what are your thoughts on some of the more I guess more exciting aspects of like the medical examiner and psych stuff and
so what interests me about this is just that it's a very unusual posture for there to be independent medical examinations and potentially testimony about diagnoses, treatment, things like that. So the context for this is that Johnny Depp has alleged that Amber Heard has received some fairly red flag types of psychological diagnoses, mainly in the, axis 3 personality disorder types of things. Amber Heard denied that in the UK, denied that she had any type of diagnosis like that. But we saw that there was a recording that had been made in the aftermath of the Australia incident when Johnny Depp got his finger cut off. Apparently, she left her phone on the counter recording, and it recorded for several hours. And among the things it captured were conversations between the doctor who was present at that point, Dr. Kipper, who was Johnny Depp and Amber Heard's personal doctor, and then the nurse as well. And there were conversations about Seroquel and how, she was normally on Seroquel. They were going to, give her an increased dose and whatever. So Seroquel is a mood stabilizer, sometimes an antipsychotic. Very common for my clients to be on Seroquel. I'm pretty familiar with it.
Okay.
Very, very often used for bipolar. And it has essentially, what's the word I'm looking for? It's a sedative in many respects. So anyway, that's not the type of thing that you get without a mental health diagnosis. So we know, or we can infer at least from that if nothing else, Dr. Kipper has probably diagnosed her with some type of mental health condition that would justify these types of medications. So that's kind of the background and the basic dispute. The reason why I find this very interesting in this case is because her personality disorder or not is really not a core issue. It's not a central issue. Whether, she lied or not is the central issue. The reason why she lied, it's interesting, it's motive, but it's not necessarily, that integral to the case. And so when you're talking about somebody's medical condition and treatments and so forth, this is a type of evidence that gets far more protection than the normal scope of discovery, like you've indicated, which is very broad. And so in Virginia, it not only requires that you have to get prior approval from the court, but you have to make a showing of good cause. And so that was an issue that got litigated, and we did not see a specific order entered. But we were able to infer from some of the subsequent pleadings and statements that were made in them, we were able to infer that motion was granted. There was a kind of reference in a footnote to the request being like eminently appropriate or something along those lines. So you don't typically say that to a judge unless, they've already agreed that it's appropriate to order that. So normally, if you're going to raise medical issues, they have to be, number one, pretty central to the case, and they have to be something that the person who is going to be examined has put into issue in some way. You can't just say, you have
I think you have a mental disorder.
Yeah, that's why you did all this stuff. You can't put it in issue for them. They have to put it at issue for themselves. Right. And so I've really been trying to sort out in my mind, if it was eminently reasonable, there's something that I don't see. There's some piece of information here that has made this central to the case that is not apparent in her answer. It's not apparent in her counterclaims. She is pleading general emotional damages, but Johnny Depp is as well. And the court has twice now rejected requests for a similar medical examination of Johnny Depp. So I'm really on pins and needles to see what comes out at trial. And if this, number one, does ultimately end up being admissible because of the higher bar to be able to get this discovery in the first place, I have to kind of assume that there's a much better case for admitting it than if it were just a random kind of discovery fishing expedition.
Right.
But at this point, we just don't know what that is. The impeachment alone is probably, in my opinion, I don't think that's enough for a couple of reasons. It's a big door to open for just pure impeachment to show that she lied. And it's, somewhat collateral. It isn't the core issue. It isn't a core lie. It's kind of just one more on a very long list of lies that have been identified for Amber. So it seems that at some point she has probably done something to put her own psychological state at issue, and it will be interesting to see what that is.
Yeah, I wonder if there was something in some kind of discovery responses, or I don't know. I mean, that is very, very, very interesting. And to be, oh, sorry, go ahead. Go ahead.
Well, I was going to say, so part of what has been very interesting about this to me, and as part of the rabbit hole that I've gone down, is because, like I said, I deal with a lot of people that have these types of diagnoses. And so it usually comes up in a situation where I'm getting their competency to stand trial evaluated. There's something, clearly not processing correctly with them. So we need to get a psych examination and see if, are these people even at this point capable of, rationally understanding the legal process and participating in it. Or it comes up with an insanity defense or something along those lines. Well, you don't have an insanity defense in a civil case. I suppose you have a kind of diminished capacity option because there is a mental state, there is an actual malice state. So I suppose it could be related if she's argued, I'm disconnected from reality. My personality disorder. Maybe none of it happened, but I really thought it did. I just, I have a hard time given, what we know about Amber Heard, seeing that being the case. So I'm used to seeing these types of diagnoses come up, but I have never seen a personality disorder actually used as substantive evidence in a trial. And part of that is just because there's a big difference between a personality disorder and the kind of mental illness that's, a psychosis or an impulse control, mania, type of issue. Personality disorder is fascinating to me because it's at this intersection of character and behavior. It has little pieces of both. And so you can kind of scoot it into the character evidence frame of looking at things, but you can also kind of scoot it into the habit frame of looking at things. And then with some of these personality disorders as well, and their characteristics, they may have a big bearing on character for truthfulness, which is, potentially admissible in Virginia court. So this as well, I'm fascinated to see if this comes in and what the justification for admissibility is going to be. Just because it's so unusual. I went researching to see if I could even find, cases where this has been done. And so all I was able to find is some pretty recent case law out of the federal courts that were employment claims, things, work environment, hostile work environment, sexual discrimination, things like that. And in those cases, personality disorder was allowed to be used to essentially argue that the plaintiff was hypersensitive, or that the plaintiff, was not going to be able to react to an office joke, was maybe going to over sexualize things that objectively would not maybe have been sexual to other people. And so it was kind of an explanation for why the plaintiff would have this perception, but that the perception itself was not objectively reasonable.
Interesting.
But it seems to be this very new, very still at this point uncommon, unique type of psychological theory in the law. So that's a very interesting intersection for me.
And